custody. Good afternoon.
Good afternoon, Your Honor.
We have Mr. Hamner here for the state.
Morning, Your Honor, or afternoon.
I'm in the habit of saying morning too. Mr. Tellis, this is on for your motion to disqualify Judge Levitt. I have read your pleadings and Judge Levitt's response, but I'm happy to hear anything else you want to tell me.
Great, Your Honor, thank you. And so what I'd like to do today is I'd like to go ahead and discuss the truth of what has happened in this case. And I hope that Your Honor allows me to finish everything that I've got to say. Because as Your Honor knows, one of the core principles of our justice system is the pursuit of the truth. Now,
I'm happy to, I want to hear the truth, but I see you have a big stack of papers in your hand. We don't have time for all that today.
Don't worry. I am only going to speak to things that are absolutely relevant.
Okay, go ahead.
Great, thank you, Your Honor. So first I'll discuss Judge Levitt's deep-seated favoritism, and I'll finish by discussing why she's engaging in this misconduct. Now, I understand that Your Honor might be inclined to grant or to give her the benefit of the doubt. However, Your Honor, the misconduct that's occurred here is well outside the bounds of any reasonable doubt. Judge Levitt, her favoritism is so deep-seated, she refuses to refrain from violating constitutional rights, and in turn, she's wasting taxpayer funds, and she refuses to acknowledge that as well. When, Judge Levitt engages in intentional misconduct, often the resources of the appellate courts, additional resources of the state, and additional resources of the public defender are wasted. And that's not to mention when often those who are wrongfully convicted have to bring civil suits. Now, all of this comes out of the taxpayers' pockets, and given that Judge Levitt has refused to stop violating constitutional rights, it seems she just doesn't care. And so, I think what is important here is to point out that this has got to stop. But let me continue though. I want to talk about Waller v. Georgia. In Waller v. Georgia, the United States Supreme Court said that evidence suppression hearings are important means of both vindicating constitutional rights and also in fulfilling the public's interest in exposing police misconduct in our community. Now, here, Judge Levitt willfully acted against these important interests by denying me a hearing because she knew that the hearing would expose police misconduct. Now, to show that a hearing is required, a defendant must show that there was a false statement, a misleading statement, or omission of important fact in the affidavit that an officer presented to a judge, and that the judge granted that search warrant based on that information. A good analogy for this is the review of a disputed contract. Now, when a judge has to review a disputed contract, the judge will strike any unconscionable or otherwise illegal terms and then review the document to see if a contract still exists. As in the contract example, here a reviewing judge strikes all unlawful probable cause statements and then reviews the statements that remain. If there is not substantial probable cause at that point, the search warrant is void and the fruits of the search are tainted. Here I demonstrated that constitutional precedent required the striking of the majority of the statements in the officer's affidavits. I should have prevailed in obtaining that hearing, and at which I should have ultimately prevailed in demonstrating that the search warrants were void. However, Judge Levitt did not like that outcome, so she willfully defied constitutional precedent that required the striking of those statements. But what Judge Levitt did essentially was she ruled that when you took these illegal statements and you put them all together, that combined, they no longer violated constitutional law. Now, furthermore, Judge Levitt had prior said that she would set that hearing as soon as the motion was filed. On the day that I expected that Judge Levitt would set the hearing as she promised, Ms. Weckerly stopped my advisory counsel in the hallway before the hearing, and she told him that I would not be receiving that hearing. Then, in the hearing, just as Ms. Weckerly had predicted, Judge Levitt decided to refuse me that hearing after all. The only logical explanation is that Judge Levitt denied the hearing because Ms. Weckerly told her that there would be no avoiding the exposure of some, if not all, of the substantial police misconduct. impartial judge defy controlling case law and renege on a promise to set the hearing just to protect police officers from lawful accountability? No, but Judge Levitt did. Early last year, I filed a motion to have Metro produce certain evidence that proves my innocence and also proves police misconduct. Metro filed a response, and they attended the first 2 hearings on my motion. The DA never filed a response, but was allowed to engage in oral argument at every hearing. And in their oral argument, the DA never cited the case law or statute. They only repeatedly made the false claim that Nevada law did not require the production of this evidence, despite the constitutional mandate for it. Now, of course, Judge Levitt agreed with the DA as long as she could. Would an impartial judge allow an attorney who filed no responsive pleading to engage in substantial oral argument? No, but Judge Levitt let the DA do that. Would an impartial judge defy constitutional precedent in favor of the DA's false claim about Nevada law? No, but Judge Levitt did. And it is clear from Judge Levitt's later actions that she knew the claim was false. After Judge Levitt, the DA, and Metro stonewalled me on the evidence for several months, I filed a petition to have the Nevada Supreme Court intervene. The week after Judge Levitt received my petition, she immediately held another hearing on my motion. Now, if Judge Levitt really believed that she was lawfully withholding the evidence from me, why would she rush to hold another hearing on my motion? The answer is she knew it was unlawful. Now, and yet you will see that Judge Levitt continued to collude with the DA and Metro to keep me from receiving evidence critical to proving my innocence and the police misconduct. When I was being taken to court that day, no one could tell me what the hearing was about. I didn't find out that it was about my motion until the hearing had already started. And only the only the DA was in attendance, not Metro. During the hearing, Judge Levitt announced that the DA would be producing the evidence I was seeking and not Metro. And this was despite the fact that I had requested in my motion production by Metro with sworn certificates as to the completeness of the production. Now, when I reminded Judge Levitt of this, Ms. Weckerly jumped in and declared that I had not served Metro, and that's why they were not there. Now, an impartial judge would have recalled that Metro filed a response and attended 2 hearings on my motion, but not Judge Levitt. She immediately agreed that I had not served Metro. It was shocking to hear a judge absolutely disregard easily verifiable facts that are on the record. Now, prior to that hearing, there was no claim that Metro hadn't been served. Again, they had filed a response and they attended 2 hearings. Clearly, Judge Levitt and Ms. Weckerly had an ex-parte communication to come up with this ridiculous claim so that Judge Levitt could order that the DA produce the evidence instead of Metro. Now, would an impartial judge do that? No, of course not. What difference does it make how I received the evidence? The difference is that by ordering the DA to produce it without sworn certificates, then the DA can lie about the evidence, and they did. Had Judge Levitt actually granted me the relief I sought in my motion, I would not now, even 9 months after filing my motion, still be fighting for evidence of my innocence. One of my requests was for the surveillance logs and videos of the surveillance that was conducted on me, including surveillance during the bribery investigation. Ms. Weckerly told me that I was only surveilled 3 total times and that there was only 1 video. However, it is clear that Ms. Weckerly lied based on information I found in items that were produced to me. In one of the surveillance logs that was produced to me, I found that the surveillance log referred to videos, plural. And that same surveillance log referred to surveillance that was conducted just the day before Mr. Gurman was murdered, a day for which I had no surveillance log. Now, there is one reason, if not 2, that Ms. Weckerly lied. The first is that the videos show that I do not walk like the killer. The second possible reason would be that if Metro was tracking me as long as, for so long, there's a good chance that they know that I did not buy the items that the killer used in that crime. So it is unlawful and immoral for the DA to willfully hide evidence of my innocence, and no impartial judge would willfully assist the DA in its efforts to do so. Sadly, Judge Levitt did, and there's no sign she'll stop. Despite a prior disqualification motion, despite a petition to the Nevada Supreme Court, despite a judicial complaint, Judge Levitt is still now withholding constitutionally mandated evidence from me. Now, from the bench, Judge Levitt outright denied me 2 sets of evidence, claiming that they were irrelevant. There was no logical, good faith reason for doing this because the evidence she denied me was similar in form and function to other evidence she did grant me. In my production motion, I had requested emails between Detective Gaddis of the homicide investigation and Detective Jappy of the bribery investigation. And Judge Levitt granted me those. But I'd also asked for emails that were related to the drafting and the submission of search warrant affidavits. Facially, both of these requests were similar. They were emails. But why would Judge Levitt grant the one but not grant me the emails from the affidavits? The only logical reason is that Judge Levitt was likely informed that the affidavit emails were damaging to Detective Gaddis. And also the same can be said for the search warrants from the bribery investigation. Bribery investigation. Judge Levitt allowed me only one of these search warrants. It was the one where Metro was given authority to track me by way of my cell phone. Judge Levitt refused me the other 7 search warrants, declaring that they were irrelevant. However, they are relevant. Bribery is a financial crime, and it is very likely that Jappy's team sought the search warrants to go through my finances with a fine-tooth comb. So, again, showing that this occurred would show that I did not buy the items of the killer used in the crime. This is, again, evidence of my innocence that was denied to me. So, would an impartial judge deny a defendant evidence that likely has proof of his innocence while granting him similar evidence that is known to have no such material? No, but Judge Levitt did. Judge Levitt also facilitated the DA's courtroom efforts to harass me and make me appear clueless. In one hearing, Mr. Hamner, attorney for the DA, was allowed to directly ask me the following question. Just to be clear, he has all the videos of the neighborhood cameras picking him up when he killed Mr. Durbin, right? You've got those, right? At that point, an impartial judge would have admonished Mr. Hamner that that kind of conduct was inappropriate. What did Judge Levitt do? She said, well, I'm assuming. And then from there, Mr. Hamner was allowed to continue questioning me, and question me in a way that made it appear that I didn't understand the difference between evidence that was produced and evidence that was seeking. An impartial judge would not have allowed Mr. Hamner to do that, but Judge Levitt did. In a later hearing, Judge Levitt immediately pounced when I was asking a question that it appeared might be directed to the attorney for Metro. So from that you can see that she knew it was improper for one party to directly question another, much less for Mr. Hamner's purposes. So Judge Levitt has facilitated the DA's unprofessional, immoral, and unlawful behavior in this case, and the DA has returned the favor by protecting Judge Levitt from exposure of her misconduct. Now, as a citizen, I have a lawful right to request information from our government by way of Freedom of Information Act request, and I did. I requested from Clark County the appeal statistics for Judge Levitt, and also emails between her, the DA, and Metro. Now, if any other citizen had made these Freedom of Information Act requests, then Clark County would have had to comply. However, Assistant District Attorney Christopher Lawley blocked fulfillment of my request, lying about the law and the nature of my request. In a letter blocking my request, Mr. Lawley cited to Tennessee and Ohio State court decisions to claim that items related to criminal discovery could not be requested by way of Freedom of Information Act requests. Never mind that even if the cases were applicable, the cases would not have given Mr. Lawley that authority to block my request. There's also the fact that Tennessee and Ohio state laws do not apply in Nevada. And beyond that, the statistics and emails that I requested had nothing to do with proof of innocence or guilt. They were not related to criminal discovery. They were related to Judge Levitt's misconduct. Mr. Lawley lied and knowingly violated my First Amendment right to the information to protect Judge Levitt from accountability. Now, this is further evidence of the improper relationship between Judge Levitt and the DA. As you can see, there's no doubt that Judge Levitt has a deep-seated favoritism because it has already resulted in numerous unfair judgments. Of course, I want to finish by discussing the why. So, and for you to understand, I have to go into just a little bit of background. You may or may not recall that, or you may or may not have heard that I believe that Compass Realty framed me for Mr. Herman's murder. Up until the day I was arrested, I was pursuing exposure of Compass Realty's thievery and probate cases. Compass Realty was opening cases to sell homes of the deceased to Compass Realty's partners at low prices with no public auction, so the partners could later sell those homes for as much as double. The money that should have been going to families was going into the pockets of these guys. Someone was directing that the homes be damaged before the appraisals occurred, so that these homes could sell to the partners for less. In a previous hearing, I mentioned the case of Recep Abdul. This would be in Judge Levitt's courtroom. In that case, Compass Realty filed an inventory report that showed a date of death condition of the home that had photos of the home with no flooring and no kitchen. When I say no kitchen, I mean no cabinets, no counters, no sink, bare walls and a kitchen. And this is one of their MOs for reducing values of the homes. And again, Your Honor, you'll see the point of what I have to say here very shortly. And the person who was in charge of this, I believe, was a man by the name of Adam Fenn, an agent for Compass Realty. And that information will be relevant in just a moment. In early 2022, I approached DA Wolfson about opening a criminal investigation into Compass Realty. He referred me to Detective Jappy in the Public Corruption Unit at Metro. I met with Jappy, gave him my materials, and his team went to work. Not long after that, Jappy told me his team discovered that Compass Realty never reported personal property such as vehicle, jewelry, firearms, or other items of value, despite having opened over 200 cases. Now, Detective Jappy told me his team would be setting up sting operations, documenting the items of value that were in the homes before Compass Realty had a chance to clean them out. And of course, obviously taking appropriate action once they built the case. The day or so after I talked to Jappy, I spoke to Mr. Wolfson and told him the good news. Mr. Wolfson said he already knew. He said that he and Jappy are good friends, and that he keeps on top of all of Jappy's cases because those are the big publicity cases. Now, after that, I didn't hear anything more, and recently I found out why I believed. I discovered that Adam Fenn of Compass Realty donated to Wolfson at the end of March 2022, not long after my conversations with Wolfson and Jappy. Wolfson's first quarter 2022 contributions and expenses report that shows Adam Fenn's donation is available for public download at the Nevada Secretary of State's website. The donation is on page 4 of that report. Also available for download is my successor Rita Reed's second order report that shows that Compass Realty donated to her, and Adam Fenn also donated to her 2 weeks before Mr. German's first article. So the investigation into Compass Realty went nowhere, and later when I continued my work against Compass Realty, Detective Jappy opened a sham investigation into me, complete with surveillance. And this was just a little less than a month before someone murdered Mr. German. You can see why maybe Mr. Wolfson wants to be convicted at all costs. Why he wouldn't mind that, or why he made Weckerly and Hamner lie and break the law to convict me. And I imagine that he didn't want me to discover and expose that Adam Fenn, the man that we were all trying to work together to build a case against, was giving him a donation. Interestingly, another attorney told me that Wolfson had been known to take donations in exchange for leniency. checked a handful of names on Wolfson's second quarter report and found that donors Sol Sayek and Leonard Ambrosino had both been convicted by Mr. Wolfson in the past. It's kind of strange that these gentlemen would donate to the man that convicted them year after year. And the attorney that told me about this leniency in exchange for donations told me that Paris Hilton was one of the most famous examples of this. Now, I didn't get to check that, but if the records from back then are available, then I'm sure that it can be easily checked out. So, this is Steve Wolfson's reason for withholding evidence, for trying to break every rule in the book, and I believe that Judge Levitt knows it. I believe that Judge Levitt wants to protect him, and I think they didn't want me to find this information out. So, I mean, what else really explains her deep-seated favoritism and these numerous overt acts of misconduct, Your Honor? There's nothing, it's extreme what she's done. It's inexcusable. And Your Honor, I believe that if you do not disqualify Judge Levitt, respectfully, I think that it's going to send a message that, you know, money can buy anything, even the wrongful conviction of an innocent man who's just trying to stop crime. So in order to protect my constitutional rights to prove my innocence, Your Honor, I'd like to ask you to please disqualify Judge Levitt. And as far as those reports, I've got copies here if you'd like to see them.
It's okay.
Thank you, Your Honor.
Thank you.